Good afternoon, everyone, and thank you for joining us today. I would like to welcome you to Novus Law Firm and FortneyScott's Labor and Employment Update for Higher Education, Campus Labor Relations Developing Issues. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. This briefing will be recorded. Today's webinar will focus on campus labor relations, including a detailed discussion of the National Labor Relations Board and related union-friendly laws and initiatives that are anticipated. Attendees will learn strategies and steps that their institutions can take to address these issues and activities proactively. The presenters include attorney Natasha Baker from the Novus Law Firm and Fortney Scott attorneys Elizabeth Bradley and David Fortney. I will now turn the program over to David Fortney to start our webinar.
Great. And Valerie, thank you very much. And it's great to appear, obviously virtually, with both Natasha and Liz. It's great to see both of you again. And we welcome everyone from around the country on what is a very blustery winter day for most, I know. So today's topic, we're going to delve into the campus labor relations issue, which is really, we believe, about to unfold and explode in many different ways. I'm going to be primarily your moderator for today. I'm going to cover a few points, and let me start with a couple of housekeeping points, and then we'll delve right into it. First, obviously, although the three presenters today, we are all counsel, the purpose of today is to provide you with very timely updates and information about a number of legal developments. The purpose is not to provide you with legal advice, and obviously we would encourage you to confer with your counsel, in-house or outside counsel, as the case may be, in order to get advice to understand specifically how these developments impact your specific organization. So, with that said, that's the lawyer disclaimer. Now let's just jump right into it and talk about what we've got. We're going to spend the first part of the program talking a little bit about some of the recent labor law developments, some of the significant ones. We're going to spend, a third to 40%-ish of our effort on that. And those are sort of foundational points so that we're sure that everyone is up to speed on the latest. And I'm just going to put a technical note out. Natasha, you need to camera back on or whatever we've got going on there. But I'll just keep going. There you are. Hi, welcome back. That's okay. Welcome to a live webinar. So we're going to talk about some of these foundational issues on labor law developments, just to ensure that all of you have the latest on what has occurred there. And then we're going to pivot right in and talk about which is really the heart of it, how these developments affect and impact in the higher education space, because there are some very unique, specific developments there with more to come. So, without further ado, let's jump right in and talk about some of the basic changes in the federal landscape. Next slide. At the National Labor Relations Board, as they say, elections have consequences, and certainly this election's had a lot of consequences. But with respect to today's discussion, at the federal agency that governs the duty to bargain and recognize unions and what our obligations are as employers, the agency, the National Labor Relations Board, had a pretty unprecedented set of changes. Of course, the National Labor Relations Board, that is this federal agency, and effectively everyone on this call is subject to that agency. And there are two components of the NLRB. One is the Office of General Counsel. The Office of General Counsel is a little different than the General Counsel might be within your home institution. Because at the National Labor Relations Board, not only is the General Counsel the legal advisor and so forth, but the General Counsel is also the chief, if you will, prosecutor. The General Counsel determines what cases will be brought forward and effectively determines what cases will be decided by the Labor Board members. And the labor board, those are, and the general counsel is appointed by the president and confirmed by the U.S. Senate. There are 5 members of the National Labor Relations Board. They are the, if you will, the deciders for the agency. That is balanced. Currently, it's balanced with a 3-2 majority, 3 Republican, 2 Democrat. The big development is that although the statute says that members of the labor board can be removed for cause and so forth, the general counsel has always, for nearly 75 years, been viewed as sacrosanct. The general counsel is appointed for a fixed term, 4 years. The general counsel, after being approved by the Senate, is, absent misconduct that has never occurred in the history of the labor board, stays for the end of the term, and they either can be reappointed or someone else is appointed. Obviously, those 4 years does not necessarily relate to the political cycles that occur for president and so forth. So in the case, for example, when President Trump became president, President Obama's general counsel, Richard Griffin, was in place and remained there for the first 10 months of the Trump administration, frankly, advocating policies and having the board decide issues that were completely at odds with what the Trump administration would have preferred the board to consider. In this case, literally on the first day of his administration, President Biden, when he came in, looked and said, wow, one of the agencies that's really important as I look out across the entire federal landscape is this National Labor Relations Board agency. And he sent a letter to the general counsel about 1 hour after he was sworn in, saying, by 5 o'clock today, I want your resignation or else I'm going to make a change. Then General Counsel Peter Robb, who is staunchly pro-employer and candidly quite at odds with President Biden's policies and those of the AFL-CIO, as you might expect, said, thanks, but no thanks. I was confirmed by the U.S. Senate, appointed. I have a term. I will complete my term, which, by the way, would have been November of this year. The president said, well, thank you, no, but as of 5:01, you're done. He was fired that afternoon. Then his deputy, who also was a political appointee, she served for less than 1 hour as the acting general counsel. She was fired. Now, you got to have someone to run this function. So they looked around and found a long-serving career employee, happened to be from Chicago, Peter Orr. And Mr. Orr was known to be quite sympathetic and supportive of the president's agenda. So he was put in place as the acting GC. Most recently, actually Wednesday of that would be yesterday, would be the president formally who the new nominee is going to be, and that's Jennifer Abruzzo. Ms. Abruzzo is one who was well received by the AFL-CIO. The president of the AFL-CIO, Richard Trumka, said this is someone who's going to fight for workers, who's going to restore balance. That means rule our way. That's kind of code talk for that. And we're delighted. Ms. Abruzzo has done a number of different positions at the National Labor Relations Board before. There's no question that she is competently, fully qualified, and most recently has done a stint with the Communication Workers of America. So she's very, very well qualified and will likely in the Senate, and we've discussed that in prior discussions, she will be confirmed even if it's 50-50 tie with the deciding vote being cast by the vice president. So I think that that's something that is important, that and at the moment, so Mr. Orr will continue as the acting general counsel until, and I'm assuming Ms. Abruzzo will be confirmed. It may be a bit contentious. In fact, we expect quite a few fireworks. The business community has been quite supportive of the Biden administration, or at least not actively hostile to a number of initiatives that have been discussed. This one, though, I think we're about to see the traditional heated opposition by the business community. And I think that that's something that we anticipate will be some fireworks. One other point to make for anyone on this call that may have an active matter in which the acting general counsel has either issued findings, filed a complaint against you, something like that. A number of parties, primarily employers, but interestingly, some unions also, are raising as a defense that Mr. Orr was improperly appointed as the acting general counsel because of alleging that it was a violation to prematurely remove Mr. Robb as the general counsel. And there's no question Robb didn't engage in misconduct or misbehavior. It was just purely, politically, you're not supportive of us. We want someone who is. And everyone agrees on that. So the question is, will all the decisions made in the interim by the acting general counsel be subject to being provide a foundation for legal challenges to all of the intervening decisions, both by the general counsel's office and ultimately by the labor board? Stay tuned. In the past, when there have been problems with the general counsel, that has been the case, and those decisions have been upset. Let me just pause there for a moment. Natasha or Liz, anything to jump in on any of those points?
I think it's going to be an interesting, between the removal of Robb prematurely and the nomination of Jennifer Abruzzo, I do think this is going to be one of the first real contentious fights that we're going to see with the employer community and the Biden administration. Right. So I do think this is going to be interesting to sit back and watch.
Yeah, agree.
Yeah. And Marty Walsh, who's about to be confirmed this week as Secretary of Labor, is fully expected to be confirmed, who is, again, he's a card-carrying union member, going to become the Secretary of Labor. And although he's a kind of a go-along, get-along, and the business community said, we're looking forward to working with you, the Labor Board is not part of the U.S. Department of Labor. It's one of the semi-independent agencies, just as the EEOC. And there's some other agencies that are examples of that.
Right. But I think those are interesting strings to pull through, because seeing that the new head of Department of Labor is a strong union supporter, and then some of these aggressive changes here within NLRB, I think that really emphasizes why looking and monitoring what's going to happen with labor law is going to be important for both union and non-union employers through the Biden-Harris administration.
And we're going to really jump into that. This will be probably the strongest position that the unions have been in. I mean, you'd have to really go back probably to the 70s. I'm talking pre-Ronald Reagan, before we're about to see the period of influence that big L labor, organized labor, has on public policy, and the overt willingness of the White House and an administration to further the interests and initiatives and priorities overtly of organized labor. And Joe Biden, I mean, he's unabashedly a supporter of organized labor, and he is, in that sense, an old-time politician. You brought me here, and I'm going to thank you for it. So I think we'll see that. All right. Well, let's talk a little.
The other thing to keep
Natasha,
in mind,
I'm sorry.
Yeah, the other thing to keep in mind, I got my webcam back somehow.
Beautiful. Welcome back.
Thanks. The other thing to keep in mind is with these changes and with the change in priorities, it will affect all employers who are subject to the NLRA, not just unionized employers. And we'll talk a lot about that today. But if you're on call and you're listening and you're like, well, we don't really have unions, this is interesting, but this isn't happening to us. The Section 7 rights and the expansion there that we're going to talk about are going to apply to most everyone on the call, from what I can see.
Absolutely. So don't drop
yet.
That's
right. Yeah, don't drop yet. No. So that's first clear indication. Second, there are a slew of labor law changes that are going to be implemented. Now, some of these have already started, and that includes with the new acting general counsel. We've just explained how we got there on that individual, Mr. Orr. He is withdrawing a bunch of guidance that was issued within the last 2 or 3 years that was highly favorable for employers. All that's being withdrawn. Number two, there's new pro-labor legislation. We'll touch on that a little more that is being introduced. We do expect, by the way, that with respect to some of these changes, whether they're enacted through legislation or ultimately through executive order and imposed either as ties to federal funding on federal contractors or grant recipients, and I think we've just defined everyone on this that's joining today, you're covered by what the changes we're anticipating, could be subject to the types of changes that are now being imposed already. So new legislation, the PRO Act, we'll talk about that briefly. Changes to the joint employer and independent contractor standards. Those of you that are California-centric, that the earth has already shifted for you, you've dealt with those, but there's still the other 49 states, I know some in California, Natasha, forget about that. There are 49 other states, and they don't necessarily align or follow those California standards. And so the issue of who is a joint employer and who's an independent contractor, this is very important because the statute deals with employee rights. And so who is an employee is very important. And finally, and you're going to hear us talk about this today, the concept of Section 7 rights. Section 7 rights, Section 7 of the National Labor Relations Act, as we refer to it, is really the right of individuals to take concerted activity for the benefit not only of themselves but for others. Very simple example. If I say, I don't think that my pay is fair to my employer, that's individual activity. If I say, my pay, the way you're paying all of us, all the lawyers that work here, including me, we're really being treated unfairly. That's concerted activity. I don't have a union representing me. There's this separate statutory protected right to raise and take certain activities in order to advance the mutual interest of those that are similarly situated. So that's a very powerful concept that I think many employers, non-union employers, to Natasha's point a moment ago, don't appreciate that the statute, whether you have a union or not, what I just described to you, what we call Section 7 rights, concerted activity rights, do apply. Liz.
Well, I was going to say, to tease that out, and we're going to talk about it in a later slide, David's example of what's concerted activity and what's not, that's starting to get blurred. And that's the expansion of what is protected concerted activity is starting to be more and more an individual complaining about individual concerns. So, and we'll tease that out on a later slide.
Okay. All right. Well, let's move to a later slide. And Liz, maybe you can talk a little bit. I referenced generally the protecting the right to organize, or the so-called PRO Act. What employer groups are concerned, and why is that? What is this?
Well, first of all, so the PRO Act is a wish list. So don't pull up the PRO Act and think that it's going to get enacted exactly as written. There is going to be some give and take in it. So, but it is the key initiatives and the goals of the Biden-Harris administration and likely the existing leadership of the National Labor Relations Board. So you should be familiar with the provisions, but also knowing that it won't 100% be enacted. But what's really interesting is this is going to be the first time that there has been substantive change to labor law, the National Labor Relations Act, since 1959. So this is an old body of law that has been in place, and this is going to be the first time, and as David mentioned before, this is sort of the first time that the union has the strength and the support to be able to push through these changes. So we definitely expect certain provisions of this to come into place. And on the next slide, we have some of the key components that we are worth talking about here today, and we kind of want to raise up to your attention. So the very first one is replacing the secret ballot with card checks to make unionizing easier. This is scary, okay, in my mind. So, normally a union has you sign a unionization card saying, I'm interested, and then they use those cards to then petition to get an election. And the election is secret ballot. So you may sign a card with your coworker next to you and you want to go along and get along. Oh yeah, I'll sign the card, knowing that you may not vote for the union. You may choose to not show up on the day of the election and just say, I'm not going to participate. There's employees have a lot of options. What's interesting is under the PRO Act, they want to have it so once the union has a majority of the cards signed, they are recognized. It's getting rid of the secret election, which I think is really going to drive peer pressure and going to remove employees' individual rights. I mean, they're couching it as advancing the right to unionize and organize, but I also think it's taking a lot of individual choice away from the employee and allowing sort of workplace pressure and bullying into that decision.
Let me just add, Liz, that card check occurs in secret. In other words, the employer is not informed that card check's occurring. This occurs quietly. There's no opportunity for the employer to present its views or insights, considerations for people. So just as Liz described, individuals may be presented with, won't you sign this card, dynamic, and which under the law today, all the card signing does is triggers potentially a secret ballot election with both sides given the opportunity to share their view, just like a political campaign should be. I won't say they always are, but should be, where each side, can provide views and then voters make an informed decision via a secret ballot. That's how today it works, but this would allow something different. Okay?
And on campuses, what we saw, at least out here, when campuses were being organized, in the context of shared governance, and people on campuses are used to taking things to committee, taking things to a vote. Everybody signed the card. They're like, let's take it to an election. Let's see how this plays out. Let's hear the pros and the cons. I mean, that's just how higher ed. So this is going to be an interesting development on a campus.
Absolutely. And also, another interesting is, how do they define their units? So this could be a complete surprise because they can get cards, see who the cards are, and then decide, oh, we're going to go with a smaller unit. We have that majority. We can go through. And unless you have an employee who is concerned about this and raises it, you're going to get no advance notice that you now have a union. So there's definitely concerning elements of this. And I think both employees and employers should be very concerned about this element of it. Another important part of it is they want to eliminate the right to work statutes. And so under right to work, that says you cannot be required to join a union if you're coming into a position that is otherwise unionized. So you cannot be mandated that you have to be a union member in these right to work states. And that is one of the key provisions of the PRO Act is to eliminate that. So that if you are an individual coming into a position that is unionized, you will be required to join the union, required to have part of your wages go to union dues. So that removes the right to work. And that too, I think, is a significant concern, both for employers as well as the individual employees. Quickie elections. Now, this has been a kind of shifting sand issue here. So back in 2015, a rule was put in place that dramatically shrunk the time frames for elections. And then in December of 2019, the Trump administration issued a rule that gave some of those time frames back, kind of eroded some of the real quickie election rules from 2015. Here in the PRO Act, they are looking to reinstate a lot of those very short time frames. If you're not getting the card check recognition that we talked about with, if you are having the secret ballots, the PRO Act is going to shrink those timeframes. And the real intent and goal of that is they don't want employers to be able to have what they call anti-union campaigns. So the concept is to remove that opportunity. And I do think it's very interesting because even in the Build Back Better materials, they do talk about it in the negative that employers put on these campaigns against the union. But I also think, employees have the right to understand what they are potentially voting for. And so while yes, there may be benefits to be joining a union, there's also, the employer has a right to say, here's the flip side of that argument, and here's the benefits of not being in the union and the greater flexibility that we have.
Apologies.
Whoops.
I couldn't hear what you said.
Sorry, my Apple Watch was listening to me.
Your Apple Watch is talking, Kim.
Excuse me. So so under the PRO Act, those timeframes would be shortened. So employers need to be prepared that even if you're not going to have recognition through card check, your opportunity to have your information out there, your anti-union messaging is going to be much more limited under what we expect under what will be enacted.
Several of these, I just would say in the higher ed context where kind of the free and full ability to debate and then to make informed decisions, which is really so recognized in the higher ed community generally. some of these feel quite at odds with some of these proposed changes, with those concepts, but nonetheless, that remains to be seen whether Congress will agree to all this.
All right, exactly. And one other piece to point on here before I do transition it to Natasha, who's going to handle the independent contractor piece. One other, the increase private right of actions, compensatory and punitive damages. So under the PRO Act, they're going to increase the penalties for interfering with the right to engage in concerted activity and various other penalties with regard to violation of these laws. And one key element is they do want to hold employers and the executives personally accountable for these violations. So your provosts, who are your executives? Are they saying they're going to hold deans? I mean, this could be a very broad and expansive personal liability element when it comes to higher ed, and how do you define your executives, and how will the act define executives for this type of personal liability. And that is, again, attaching individual liability to these types of violations is very concerning, and it is intended specifically to discourage companies and their executives from engaging in activity contrary to unionizing. And so moving on from there, the very last piece under the PRO Act is the solidifying the independent contractor status, codifying that, and also a more expansive definition of joint employer. And so that's what's interesting is these issues are being played out both here in the potential PRO Act as well as in Department of Labor in their rules. So I'm going to transition it over to Natasha now to talk about those issues in greater detail.
Great, thanks. So if we want to go to that, this slide here. So the joint employer rule and the independent contractor rule have been flip-flopping back and forth. The appropriate test for each status has been flip-flopping for years. And so again, we're waiting and holding our breath to see, potentially as a result of the PRO Act or as a result of the prior joint employer rule that was issued under the prior administration. We're again waiting to see what this test is. At one point, several years ago, we submitted a comment to the NLRB saying, just pick something. Pick something, please. Stick with the standard enough. Because what the problem is really being able to assert contractual relationships either with another entity whose employers you might or might not share, or with another business that you want to classify as an independent contractor. So we'll start with the independent contractor test. The PRO Act would essentially codify what's known as California's AB5 test, which is often referred to as the ABC test. This is a very, very difficult test to meet in order to classify a worker as an independent contractor. So if you can't meet all three elements of the ABC test, then you are an employee, which for the National Labor Relations Act purposes means you are then an employee for purposes of joining a union. So if you start to think about on your campus, they're usually called consultants on campus. They're your 1099 employees. Start to think about the range of people who are classified as independent contractors, and then apply the ABC test. You can see where you don't really think of those people as employees normally. It's someone who's free from your control over the performance of the service. The service is outside of your normal business operations. And so again, that's a very limited range for institutions of higher education. And then of course that the independent contractor or business is independently established. So you gotta meet all three of those in order to satisfy the ABC test. So the example that I use is when an institution hires outside counsel, outside lawyers, that will likely pass the ABC test. And so when ABC first passed in California, the general prevailing wisdom was it's nearly impossible to classify anyone as an independent contractor under the ABC test. There have been subsequent exceptions that have passed by legislation and by initiatives. But if the ABC test were implemented into the NLRA, it would, I think, be very difficult to classify people as independent contractors for the purposes of voting. So that's just one of the things that we're keeping an eye on. I apologize. I don't know why my web Cam is going in and out. It's like a brand new hip gaming webcams. I don't know what the deal is, but I'll just keep talking. I'll just keep talking. So that's the independent
Just keep
contractor
rolling.
rule that might happen. And then of course there's the joint employer rule. And this is one that has flip-flopped back and forth many times. You may have heard of this under the Browning-Ferris standard. So the distinction here is you've got two entities and you want to know, can they be considered joint employers for the purposes of unionization and bargaining? So that's something as an institution you want to know when you're engaging in contractual relationships with other entities such as Sodexo, such as Bon Appetit, facilities, anything that you're engaging with. You need to know what's the appropriate test and are we going to be considered a joint employer for the purposes of labor relations. So that's how it's going to come up on your campus, is with respect to your contracting entities. So the most recent rule that was promulgated under the Trump administration was a very narrow definition of joint employer status. It says an employer may be a joint employer of another employer's employees only if it possesses direct and immediate control over the essential terms and conditions of employment. Really, really narrow. So this is much different than what we saw under the Browning-Ferris standard, which was indirect influence and control and contract reservation can create a joint employer relationship. And so number one, we need to know, like, what is this new test going to be? If the PRO Act proceeds, it's likely going to be that much broader definition of joint employer, of indirect influence and contract reservation. And then what does that mean for higher education? Well, it's extremely problematic given how risk management is going, given how your insurance companies are requiring you to insert control and language into your contracts with other entities such as facilities, Sodexo, et cetera, to prevent against sex abuse, to report sexual harassment, to make sure you're engaging in background checks. So the more risk management that is controlled via contract, if you were to examine that under the proposed PRO Act standard, the more you're going to look like a joint employer. So you're going to have to really analyze where do you need to reserve contractual control and how could you distinguish when you don't want to be considered a joint employer. So that's, to me, the significance there is that it's ripe for a lot of joint employer assessments. Liz, did you want to jump in?
Well, I do. I think in addition to for labor and organizing purposes, remember, any of you out there who are federal contractors, this joint employer is rising up now with OFCCP as well. And now OFCCP is taking the position that if you are a joint employer, those individuals need to be in your affirmative action plan. And now, wait a minute, you're supposed to include your outreach recruitment, your applicant data, and your hiring, but you haven't selected these people. You know, the employees running food services for you, you're a joint employer. You have none of that underlying data. But OFCCP is taking the mindset of, if there's joint employers, the employees need to be in the plan who controls their day-to-day activities. So that's just something. So this joint employer issue, it is hitting on a number of different legal compliance issues.
Right. And that issue, Liz, that you just described is one that we, in real time, in fact, have pending in several open audits that the Labor Department has very aggressively asserted that. Well, let's talk about Section 7 rights. Switch to that. Natasha?
Sure. So as we were sort of teeing up earlier, the concept of Section 7 rights applies to anyone who the NLRA has jurisdiction over. So this isn't just unionized workplaces. So if you meet the threshold commerce requirements, if you meet the standard for an employer under the NLRA, then you're going to be subject to Section 7 rights, which is, as Liz was saying, 2 or more people engaging in protected concerted activity. And so this, again, the pendulum is just swinging back and forth. And I remember distinctly being at a NACUA employment conference probably 7 years ago. It was the one in Denver, and talking about how the pendulum had swung back to Section 7 rights. And what this functionally means is the broader that Section 7 is construed in terms of work rules, the more it impacts your handbooks, it impacts your work rules, it impacts your confidentiality agreements, your employment contracts. And so really it has been a sea change over the past several years as to what are permissible work rules and what are not permissible work rules. And so we anticipate, given everything we've said so far today, that Section 7 rights will be broadly construed such that we're going to have a sea change in work rules. Again, changes to your handbook, changes to any employment agreements that you have in order to allow people to engage in Section 7 activity. So in Boeing, but you may have heard about the Boeing decision. That was a big decision in which the NLRB overturned Lutheran Heritage, which had held that even facially neutral work is unlawful if, when reasonably interpreted, would interfere with Section 7 activity. Boeing, again, narrowed that, of course, looked at the nature and extent of the impact on NLRA rights and whether the employer had legitimate justifications associated with that rule. We think we will go back to the much broader standard of, facially neutral work is unlawful, even if, when reasonably interpreted, would interfere with Section 7 activity. So that's the change that we think we'll see with respect to Section 7 rights. And what this means is you have to go through your handbooks, your policies, your procedures, your employment agreements, your separation agreements with a fine-tooth comb to see what can be considered interfering with Section 7 activity. So that's usually the change that we see when this happens. And I think, Liz, you were going to maybe jump in. I don't want to steal your thunder if you're going to jump in.
Nope.
Okay.
No, I scratched.
No, and and it's not only the written policies and documents, handbooks, but even when complaints and potential disciplinary action or responses are being given to sort through. And keep in mind, everything that Natasha's just briefed us on, these are for workers who are not represented by a union. There's none of this union campaign activity, secret ballot stuff that Liz was talking about. These are folks today in a non-union environment have these rights, and those rights are likely to expand pretty quickly. All right. Well, let me just quickly touch on another kind of, I view these as kind of gotchas, things that you would think kind of common sense that don't always make common sense. What about your email? Let's talk about the basic email communication. Do you have the right to do anything you want on the email? Most of the time, the general answer is no. It's to be used for work-related communications, as are other communication tools that may be at disposal, company-issued phones, anything. But let's just stick with the email as the easiest one. Well, the question is with respect to if union organizing has started or there are efforts relating to union issues that you as an employer may say, look, we don't want those kind of communications run across our email system, that's not consistent. The university's business, the college's business is X, and that's kind of outside. You have your personal opinions, but you've got personal chat boards, social media, something where you put your personal view. That isn't part of our official communication. Well, for many, many years, the ability to restrict and say non-business communications should not occur on the college or university's email system has been pretty well black letter law. That was changed for a period of time, and that change occurred in 2014 by what was then called the Obama board. Well, that, again, to Natasha's point, the pendulum swings. That was reversed by the Trump board, and the more traditional that, the email and related similar communication systems are used for work-related communications in furtherance of the university or college's interests. That, we believe, is on the shortest of short lists, and this goes back all the way back to the first point we started with. Why is the general counsel important? Because the general counsel can now find a case that will tee up this issue and allow the board, when the composition of the board is right, to wade in and decide that issue and make a change. So we actually think that's going to change, and it will, again, going back to Natasha's point on basic policies, how email and other communication tools are used, require you to refresh and sort of, I say, suspend common sense and think, well, even if it's not in the college or university's interest, we may have to allow these types of communications and how that goes down. So I want to turn, unless anyone's got anything more on that point. Okay, now we're gonna make the swing, and we're gonna swing. So we've covered a lot of these foundational points, and I really want to talk a little bit about higher ed and what we see and how this can fit. And I'll kick off this module, and this is the point that I think really now we're going to take all these points. We've educated you on the foundational elements. They'll start with collective and concerted activity. That's these Section 7 rights, when people are acting together in concerted activity. We are seeing the decisions on that. I think the one that's perhaps most well known is because it's received a lot of press reports and attention, involves Google, and it's just because of the name of the organization. But if you think about that, individuals who were disciplined for engaging in inappropriate activities by Google. I mean, those are the undisputed facts. One of them was, conservative views, defending white nationalist ideals. There were a whole string of things. And Google basically said, look, under sort of our code of conduct, our kind of workplace decorum codes, we're not going to tolerate those sorts of discussions. And they imposed discipline. Those are codes that I would suggest each and every one of your organizations has in place. I'm sure you have it. And so the question and the response by the individual employee was, well, wait a minute. I wasn't just talking. I have a protected right to talk about these issues because they're of mutual aid and interest, and there are others that share these views, and I have to be allowed an opportunity to express these views. That was sufficient to start stating claims under Section 7 for mutual aid and benefit, and it's taken off from there. So let me just pause. Liz, did you have something you want?
Yeah, I mean, I think that's where
I could feel you.
As I teased, right? I think that's where I teased before, where I think it's starting to strike. Is that you're expressing your conservative views? Is that a terminative condition of employment? Is that
right.
a traditionally concept of the concerted activity that I think is intended to be protected? Arguably, I think no, but I think that is where it's starting to, the line is starting to become broader.
So we will see this type of discourse and the tension between, kind of the work-related communications, what constitutes work-related, and what can be justified, particularly under this expanded definition of protected concerted activity that both Liz and Natasha have mapped out for us, how broad that is and how that is about to get blown up and be much broader. Much broader. So it's not just who gets to use the email, it's what you get to say on email, what you get to say in a variety of commentaries. So I would say, in addition, this underscores, in addition to Natasha's absolutely correct instruction on check out your policies and handbooks, think this through when you are potentially disciplining someone and run it through the Section 7 filter. Was this concerted activity? Could this be concerted activity? Am I going to end up, I'm going to win the battle but lose the war? I may discharge or discipline this individual, and now I've got an unfair labor practice charge, which goes on for X years. I'm going to put the person back with back pay, and I've got a public black eye. It's all very bad, and it can lead to a lot of other activity. All right, so that's just one. That's one example of concerted activity, how we're seeing it play out. Liz, let's go about some organizing efforts.
Sure. So in the next last portion of this presentation, we're going to talk about, and we can move to the next slide. We're going to talk about what we expect to see an increase in organizing efforts, and we're going to talk through the various different buckets of the higher ed workforce where we expect to see increased organizing efforts. So first, some landscape setting here, and this is your faculty members. So we've all, since 1980, we have yeshiva, which kind of held that your full-time faculty are managerial and therefore they're not subject to be unionized. Okay, well then that's been sort of etched away over time, and we expect that etching to potentially continue. So we have Pacific Lutheran that set forth the majority status rule. And what that said is you need to look at whether or not there is effective control, looking at the representation of faculty members on those university committees, and is there decision-making power of those committees, making sure that you're not saying they're managerial just because they have a title. And that kind of stayed in place for a while. And then the University of Southern California, recently a DC Circuit case came out that then has kind of created a two-step process for looking at your faculty. And first, it is the first step about whether faculty members as a whole are part of these decision-making processes. Then the subset of that is looking at whether the specific subgroup that is attempting to unionize are part of those decisions. So Natasha, I know you have, so this is kind of where we are going here, and we're not sure the full impact of the DC decision. We're not sure what that is going to be yet. But Natasha, I know you have some thoughts you wanted to chime in on this as well.
Yeah, so, and that's a good explanation of how sort of the yeshiva test is really essentially eroding. I think we want to think about this in the context of, particularly with COVID and the changes that have happened to curriculum as a result of enrollment declines, as a result of shifting to a hybrid model. You do have faculty raising concerns about whether, in the context of shared governance, they still have enough control over the things that they traditionally had control over. So setting the curriculum, admissions requirements, enrollment. I think as you look at your faculty and as I know we've got a lot of administrators on the call, but you want to make sure that you're upholding a robust system of shared governance. Absolutely. If you are going to claim that your faculty are in fact managerial and therefore exempt under the yeshiva test. So I think you would just do well to watch sort of the anxiety that's being raised about how decisions are being made, things are being implemented, and a lot of it's financial, a lot of it's COVID related. So just making sure that where shared governance is owed, that you're engaging in that if you expect to classify your tenured and tenure track faculty as managerial.
Absolutely, because that serves multiple functions, right? It meets the expectations of faculty members, and that's the good faith there and keeping them happy. And then it's also going to support a determination that those faculty members, when they determine that they're not happy, are not eligible to unionize. So there's looking at it 360, there is reasons to continue and engage in that shared governance.
And just back to David's point about the Purple Communications, those faculty listservs are lit, right? Like there's so much activity on those.
Exactly.
Absolutely. So the first group that we expect to see increased unionizing activity is with adjuncts. And we've been seeing that. So I don't want to say that this is something new, right? If you look back, there have been a significant number of adjuncts successfully unionizing. A 2020 study came out, and these are pretty shocking results. And this is what's driving unionization of your adjuncts. A third of them are making less than $25,000 a year. Less than 50% of them have health coverage. 25% are using public assistance programs. 75 have no assurance of it's their term to term. There's no commitment for anything long term. And so the study, we also looked at, and what were those collective bargaining agreement gains that your adjuncts received? Increased compensation. They received health benefits, professional development provisions that allowed them to, so often they're not getting much more than that term commitment because of the way, adjuncts are engaged, but they are getting other type of professional professional development benefits that allow them to move into more long-term positions. So, I think universities, need to be looking at their adjunct faculty and looking at them and saying, is there something that we can do to address these concerns? How do we stop adjuncts from wanting to be unionized? Can we address healthcare? Can we address the compensation? Be proactive in looking at that universe, because one thing that you always see is this is the low-hanging fruit. They're going to get unionized. If a union comes in and it's a quickie election, they're coming on. And then once the adjuncts are on site, are unionized, and they get that compensation bump, who's the next group that's interested? You already have the union on site, so you have to be very careful. once you get one unit in, it does start to spread. So, looking at this population, it might be a good place to start.
And I would say, if possible, and sometimes you have this information in your academic affairs office, sometimes you have it in IR, institutions often make assumptions about who their adjuncts are. They're like, oh, it's local professionals, so they already have healthcare, they already have a full-time job. I mean, what we counseled when we started seeing people, SEIU specifically organizing out in California, was do an audit. Who are your adjuncts? Like, is that really who your adjuncts are? Or are they more the freeway flyers that Liz is describing? Because you need to know that, and so you can take steps to address any benefits or things that might be lacking.
Right. Because less and less are your adjuncts, the person who is law, for example, less and less the adjuncts are not an existing practitioner with a full-time job and just taking on, extra courses. That's becoming the less common scenario.
I mean, it still happens, but I would do an actual assessment of who you've got.
Right. So moving on, Natasha, I think you're taking the next, or unless David, did you?
Yeah. No. I was going to say, let's talk about religious institutions, because this is always a really thorny, raises legally a number of challenging questions. Natasha.
Yes. So you gave me another test that flip-flopped here.
It's another one. Here you go.
I mean, I literally own a cheat sheet that's like, what's the status of the flip-flop in all of these things right now? Because every time you look up, you're like, oh, that changed again. Okay. So Bethany College. So the issue here is the jurisdiction of the National Labor Relations Act over religious institutions. So we represent a lot of small, private, religiously affiliated institutions. They're affiliated with the Methodist Church, the Lutheran Church, the Baptist Church. So, really following to see, well, again, what is the test for when a religious institution is sufficiently religious enough to be exempt from the National Labor Relations Act? And this test has changed, 4 or 5 times now at this point. The most recent decision from the NLRB coming out of Bethany College, when the NLRB held that it had no jurisdiction over the faculty at religious institutions of higher education, and they overruled the prior decision in Pacific Lutheran University. So Pacific Lutheran University, with respect to the faculty, set forth a very detailed, very in-depth test for when an institution could be considered sufficiently religious such that it would be exempt from the National Labor Relations Act, such that its faculty couldn't organize under the National Labor Relations Act. So Bethany College went back to a prior Great Falls earlier test and now has a much broader definition of what it means to be a religious institution exempt from the National Labor Relations Act. So this is something we expect may change again as we see perhaps a test case on this. Part of what people perceived as the offensiveness of the Pacific Lutheran test was it was the NLRB in the weeds in detailed analysis over what the faculty taught, how they held themselves out, whether they were required to be religious. It was an in-depth inquiry by a government agency of whether an entity was sufficiently religious or not. You don't see this in other contexts, right? Separation of church and state. You don't see this. So they just, at this point, this is another one, pick a standard. They picked the Bethany College. It's a much simpler test to meet. Is the institution holding itself out to the students, faculty, and community as providing religious educational environment? Is it organized as a nonprofit? And then is it affiliated with, owned, or controlled directly or indirectly by a recognized religious organization or with an entity, membership of which is determined at least in part by religion? So it's a much broader test to meet, because what we saw under Pacific Lutheran, as institutions have historically evolved, a lot of institutions now are historically Methodist or historically Catholic, and they weren't able to meet that Pacific Lutheran test of being so narrowly controlled and operated by a religious entity that they were able to be exempt. So this is another thing we think may change again. So for our religious institutions, we'll issue some more alerts on this as this test changes. Every few years, it's like, okay, Great Falls, Carroll College, Pacific Lutheran, Bethany College.
Well, I think it will change, but and meaning that the board will have a much broader role. The religious exemption will be narrowed by the current administration. However, when and if that issue reaches the U.S. Supreme Court, I think they are likely to totally reject the Biden administration view on this. So the pendulum will dramatically be swung in a way, and in a much more permanent way once the Supreme Court rules on that. So I think this is an area where there's likely to be a huge amount of activity. There's a lot of energy and interest in these issues from a lot of
I
folks.
was just thinking about that last night. If this goes up to the Supreme Court, like it's the opposite direction.
Right.
I'll just keep that little cheat going. Where are we? What's next?
I think that's right. Well, I won't say you need to get a life if that's what you were thinking about last night, but okay, welcome to work from home. Liz, let me go to you, and maybe we can talk about grad students, because that's also a traditional area of concern.
Another flip-flop.
And sweet target, sometimes soft target of opportunity for organizing.
Sure. So again, back to the flip-flop. Back since in 2000, the board allowed NYU's grad students to unionize. Under the George W. Bush NLRB, reversed that decision. That was then Obama reversed that decision. So then there was a notice of proposed rulemaking in September of 2019 that was going to establish a rule that undergraduate and graduate students performing services for compensation, including teaching and research that was in connection with their studies, are not employees. Well, interestingly, that notice of proposed rulemaking was issued in September of 2019. In November of 2019, Democrats introduced the Respect Graduate Student Workers Act into the House. And the Respect Graduate Students Act is an attempt to modify to say that declare that graduate students are employees. So that act has now been introduced into the Senate in January 2021. So where that stands and where this issue is going to roll out is going to be interesting. I do think that under the Biden administration, the rule will be put in place that they will be deemed employees. And this is going to be a population that is going to be eligible to unionize. And I can see Natasha has a thought.
Yeah, I was just thinking, and I just want to make sure we're clarifying this. The NLRA is applicable to private institutions because many public sector institutions, which were under their state PERB laws, already have graduate students as employees. Because that's one of the things that we ran into when looking at the NPRM was the distinctions to be made between those two statuses.
Correct. Thank you for clarifying. All right, and then I think to take it home in the last 3 minutes that we have, Natasha, student athletes.
Here we go. Who knows? Okay.
Save the best for last.
Yeah, the football players were seeking to be classified as employees. The NLRB declined to classify student athletes as employees. The NCAA has long pushed the amateur student athlete description and characterization. The NLRB's current position is that student athletes are not employees. We know that the acting general counsel, Peter Orr, supports their right to unionize. Unclear, I don't know Abruzzo's position on it, but I think, this is another area where we may see some additional activity because it is happening in the context of people critiquing athletics during the time of COVID. And if athletics is allowed to play, and if students are traveling and behaving as athletes more so than as the rest of the students, how does that lend itself to a characterization of amateur student athletes? So I think we'll see some more activity in this, probably not like really high on the list, but you never know who might bring this forward. We saw student athletes using their voices collectively in response to the Black Lives Matter actions this summer. So I think the pressure points are still there in terms of how are these student athletes to be viewed legally.
Absolutely.
The Northwestern, this case, Mr. Orr, now the acting general counsel, was involved in the Northwestern case. So it's not a coincidence that this issue is up and is one that he is very familiar with. And although the board didn't go with his view at that time, it's a new day. And I think this is one where there's likely to be overwhelmingly that the board's just going to roll the student athletes in and recognize them as employees.
Interesting.
Well, let me check and see in terms of questions.
We've got a minute left. Any questions out there?
Yeah. Questions, one or two Okay, those have been cleared off. I think that you've actually addressed the questions we've gotten. So let me go first to Liz and then Natasha for the last word.
You know, stay apprised. We will be sending out alerts and notices. This is an area of law that is going to be rapidly changing, I think, and I think there are substantial changes. These aren't soft changes that you can flow with. I think you'll need to be taking immediate action. So we will keep you apprised.
Natasha.
I would say even if you don't have a union on your campus, don't forget those Section 7 rights. Like it's something that people lose track of pretty easily.
Agreed. All right. Well, I think we're exactly out of time. I want to thank both Liz and Natasha. Great presentation today and really informative and very, very timely. So thank you both and look forward to our next meeting in about a month or so.
Great. Thanks for having me.
Thank you.
Thank you.
We would like to thank you for joining us. The next higher ed webinar in this winter 2021 series, using lawful race-conscious practices in admissions, employment, and other institutional decision-making, will be held March 18th. As a reminder, you may view previous briefings on both the FortneyScott and Novus law firm websites. Everyone who registered today will be registered for all future higher education-focused briefings. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You're able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey. And of course, if you have any questions, you may submit them via email to info@FortneyScott.com.
Thank you.
Thank you.